Today I'll be discussing on custodial violence. Custodial violence and abuse of police power have emerged a major issue of human rights concern and one of the root obstacles to democracy and development of human well-being in contemporary societies. This term, custodial violence, includes all types of physical and mental torture inflicted upon a person in police custody. It is a crime against humanity and a naked violation of human rights. The practice of custodial violence in the developing countries like India, it is however more difficult and complex. A large number of cases of police brutality take place not because of individual aberration but because of systematic compulsions. This nature of custody, it may be judicial, police, or under any institution obliged to take care of the inmates like hospitals, homes, etc., or maybe in the hands of the terrorist organizations or armed groups or insurgents, etc. The practice is widespread and gone unchecked since British days if there was no tacit support of senior police officials, bureaucrats, politicians, and judiciary. But in recent years, the custodial crimes have drawn attention of the public, the media, the legislature, the judiciary, and even the Human Rights Commission. Nevertheless, judicial activism, widespread media coverage, initiatives taken by the National Human Rights Commission, as well as the civil society intervention, have shown their concern for combating torture and upholding the human dignity. So you see, before earlier there was no such it did not come in the limelight, but now due to the judiciary, the legislature, and the Human Rights Commission, and even the press and media, they have been concerned regarding for combating torture and upholding the human dignity. Now you see the police atrocities, because when we see the custodial violence, you mean the police custody, or maybe it may be the judicial custody. And what is the role of the police? The power has given to the police, and powers in order to enable them to enforce the law and to protect the people effectively. But there has been a large abuse or misuse of power. When a case has been lodged or the FIR has been lodged, now the police, the next function is in the hands of the power police, because it is their function or it is their power to investigate the matter, and sometimes the desire to solve a case at the earliest, and sometimes plain greed that makes them to use it illegally. So you see, but Article 21, there is certain protection available to us. That Article 21 provides that no person shall be deprived of his life and personal liberty except according to the procedure established by law, which is inbuilt guarantee against torture or assault by the state or its functionaries. It is not expressly mentioned that there should be there should be no torture or assault, but it is implicit within Article 21, because it talks of right to life and personal liberty, and no person shall be deprived of it except according to the procedure established by law. But however, you see, even though we have this provision, the torture and assault have become a part of police ways, unfortunately. And in many cases you have heard about custodial deaths, and or you can say about custodial murder. So this custodial violence, it raises serious questions about the credibility of the rule of law and administration of criminal justice system. An offender has every right to tried and punished in accordance with the law, and any punitive action taken outside the ambit of law is illegal. Besides, no matter how heinous the crime may be and howsoever dangerous be the criminal, he or she has every right to be treated with human dignity. That means what? Even if an offense has been committed by a criminal, it doesn't mean, even if the offense is committed by a person, because until and unless the guilt has been proved, you cannot term him as a criminal. He will be believed to be an innocent until and unless his guilt has been proved. So you cannot take an illegal action against him. And the courts have even discouraged the practice of handcuffing the accused unless it is necessary. And several international conventions universally recognize the human rights as inalienable. And there is ample evidence of increasing police deviance in India. Incidents of brutality, extortion, and other crimes committed by police officers in different parts of the country are reported in Indian newspapers. And there has been data by the NHRC, that is the National Human Rights Commission, that the number of complaints relating to deaths in police custody reported to them increased from 136 in 1995 to 1996 to 183 in 2002 to 3. And during the same period, the illegal detention arrest increased from 112 to 3,595 and other police excesses from 115 to 9,622. Now you see there are various types of custodial violence, different methods to commit custodial violence which are applied to bring the desired results by the government agencies. So one of the type is physiological violence, which maybe like you can get it clear, like to break the confidence and moral of the victim. Following methods are used. Firstly, by communication techniques in which the victim is being given wrong information and he is tortured mentally. Secondly, by compulsion or coercion, where the victim is compelled or coerced to perform activities or to witness actions that torture him mentally, forcing the victim to violate social taboos or forcing to witness torture of other victims, etc. Then by depriving the victim the basic needs like food, water, sleep and toilet facilities, which results into disorientation and confusion. Then pharmacological techniques like use of various drugs to facilitate torture of the victim, to mask the effect of torture and also as a means of torture. Threats and humiliations which are directed towards persons in custody or the family members or friends. Next type of custodial violence is your physical violence. There are various methods generally adopted to cause physical violence or torture on the victims. They are like causing disfiguration and exhaustion, causing torture to such an extent that the victim feels fear of immediate death, forcing the victims to sleep on damp floor, making the children stay naked in extreme cold weather or under the sun in temperature for more than 30 degrees. Scratches and cuts are being made on different parts of the body with sharp objects. Use of irritants like chili powder, table salt, etc. are applied on delicate parts or on open wounds. So you see, there are another type of violence. As we have discussed the physiological violence and also the physical violence. The next type of violence is your sexual violence. It has great social and psychological impact in the minds of its victims. It may start with the verbal sexual abuse and humiliation targeting the victim's dignity. It results into rape or sodomy. And the violators or the perpetrators of this crime keep devising new means and methods according to their own mental aptitude and imagination to break the resistance of the subject quickly as well as to satiate his or her own urges. Now you see there are various methods of torture still applied by the police and the other agencies in India which amount to the custodial violence, like beating on the spine, beating with canes on the bare soles of the feet, beating with rifle butts, burning with lighted cigarettes and candle flames, denial of medical treatment, forcible extraction of teeth, forcibly lying the victim nude on ice slabs, hauling the victim on airplane position, inserting live electric wires into body crevices, insertion of metal nails under toenails, public flogging, submersion in water, suffocation, victim is crushed under heavy rollers, victim is stabbed with sharp instrument. So you can see that these are the various methods or different forms of ill treatment. You might have seen in different movies also where there has been like physical torture, mental torture, because a person cannot be only physically broken, he can also be broken emotionally, psychologically. These are also one form of the custodial violence. Now see, different forms of ill treatment may be burning alive also. Electric shocks, mock executions, rape, molestation, severe beating, suspension by arms while these are tied behind. So you see different forms of ill treatment and different methods. Now, the elements which constitutes the custodial violence: the infliction of severe mental or physical pain or suffering, firstly. Secondly, by or with the consent or acquiescence of the state authorities, and for a specific purpose such as gaining information, punishment, or intimidation. So these are the three elements which constitute custodial violence. One is your that infliction of severe mental or physical pain or suffering. It may be by with the consent of the state authorities, and for what purpose? It's for specially for gaining information, punishment, or intimidation. Now, as far as I have told you about the custodial violence, different forms of custodial violence, the elements of custodial violence, but For prevention of this custodial violence, there are protection being given under the Indian laws, which can be divided into the constitutional provisions, the provisions under the Code of Criminal Procedures, and the provisions under the IPC. Firstly, we will discuss the constitutional provisions, the provisions, the protection given under the Constitution against custodial violence. The first very article which speaks of the custodial violence is Article 20. You know, Article 20 can be divided into three parts. The very first clause, it tells about doctrine of ex post facto law. It prohibits retrospective operation of penal legislation. That means what? If, suppose, a person has committed a crime in 1990, now, during that time, the punishment was for 2 years. And if, with time, at suppose in 2020, the punishment has been enhanced to 10 years. So now, if he has committed the crime during that year, particular year, he will be punished accordingly, not on the basis of enhancement of the punishment. This is your doctrine of ex post facto law. Second clause of Article 20. It tells about double doctrine of double jeopardy. It tells that a person cannot be punished for the same offense twice. And the very third clause of Article 20 speaks of doctrine of self-incrimination, which speaks that no person can be compelled to give a witness against himself. So no person accused of any offense shall be compelled to be a witness against himself. So this three clause, it may be appear to dealing with different topics or facet, but there is a common thread running through all of them, namely the anxiety to ensure that the various phases of the criminal justice system, substantive, procedural, and evidentiary, shall not be used to oppress the accused person. The common theme is that the administration of the criminal justice system should not be so designed or implemented as to destroy the deeper and moral values of justice itself. So you see, this is the first protection available to a person who has been inflicted torture under custody. So this is a prevention against custodial violence. The second is your Article 21, and the Indian judiciary has expansively interpreted Article 21, and it states that all the state actions should be just, fair, and reasonable. And this wide-ranging interpretation has been applied to administrative procedure as well as criminal due process. And Article 21 has been read as an injunction against torture and inhuman treatment. 21 of the Constitution, it provides that no person shall be deprived of life or personal liberty except according to the procedure established by law. Now see, though this Article 21, it does not contain expressly the word or the provision against torture or custodial crimes, the expression life or personal liberty occurring in the article has been interpreted to include constitutional guarantee against torture, assault, or injury against a person under arrest or under custody. So there are various, landmark judgments given by the judiciary, because as judiciary is one of the important pillars and important organs of the government, and there are various judgments regarding the custodial violence. Some of them are like punishment which has an element of torture is unconstitutional. Prison restrictions amounting to torture, pressure, or infliction and going beyond what the court order authorizes are unconstitutional. As under trial or convicted person cannot be subjected to physical or mental restraint, which is not warranted by the punishment awarded by the court, or which is in the excess of the requirement of prisoner discipline, or which amounts to human degradation. These are amounting to custodial violence. Now see, the Supreme Court of India declared that any form of torture or cruel, inhuman, or degrading treatment would be offensive to human dignity and constitute an inroad into this right to life, and it would, on this view, be prohibited by Article 21 unless it is in accordance with procedure prescribed by law. But no law which authorizes and no procedure which leads to such torture or cruel, inhuman, or degrading treatment can ever stand the test of reasonableness and non-arbitrariness. It would plainly be unconstitutional and void as being violative of Article 14 and 21. That means any law which is inflicting torture, cruel, inhuman, or degrading treatment, it would be offensive of human dignity and it would be violative of Article 14 and 21, and hence it would be unconstitutional. And one of the very important landmark judgment in D.K. Basu versus State of West Bengal, The Supreme Court gave a guidelines regarding the custodial violence also, and it noted the ubiquity of torture and third degree method in police investigation, and it lamented the growing incidence of torture. And it held that such a crime suspect must be interrogated, indeed subject to sustained and scientific interrogation determined in accordance with the provision of law. He can't, however, be tortured or subjected to third degree methods or eliminated with a view to elicit information, extract confession, or derive knowledge about his accomplices, weapons, etc. So, this is one of the very important landmark judgments where the custodial violence or the third degree method has been prohibited. Moreover, in every police station, you will have to, outside the police station, there should be proper guidelines regarding for the person who are in the police custody, because there are various, like, preventions, protection being available to a person who is in the custody of the police. And the Supreme Court of India also ruled that the burden of explaining a custodial death lay on the police. It does not lay on the victim. Who will have to prove? The police will have to explain the custodial death in the police station. The court granted compensation on the constitutional basis in public law for the infringement of this fundamental right. It referred to its duty to enforce fundamental rights under Articles 14, 21, and 32 of the Indian Constitution and need to make the guaranteed remedies effective and to provide complete justice. That means, whenever there is a custodial death under the police custody, then the police will have to, burden of proof is on the police. The police will have to explain the custodial death. The next provision, apart from Article 20 and 21, we have Article 22, Clause 1 and Clause 2. It is very relevant for the present purpose because one of their objectives is to ensure that certain checks exist in the law to prevent the abuse of power of arrest and detention. Clause 1 tells you that no person who is arrested shall be detained in custody without being informed as soon as possible the ground for such arrest, nor shall he be detained the right to consult and to be defended by a legal practitioner of his choice. In short, you can say that Article 22 Clause 1 of the Constitution tells that a person has the right to be informed of the grounds of arrest, and moreover, he has the right to consult a legal practitioner of his own choice. Clause 2 says what? Article 22, Clause 2, it provides that every person who is arrested and detained in custody, he shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of magistrate, and no such person shall be detained in custody beyond the prescribed period without the authority of a magistrate. And both the provisions referred to above have a vital importance to the theme of the present issue. The Clause 2, which says that a person, whoever is arrested and detained in the custody, cannot be detained beyond 24 hours, and moreover, he shall be produced after 24 hours to the nearest magistrate. It is mandatory provision, and this is the protection available to a person who is under arrest or detention. Now, these were the constitutional provisions, Articles 20, 21, and 22. Now, there are various protection available for the custodial violence under the Code of Criminal Procedure 1973. They are as follows. Like Section 49 of the CRPC, it tells that the person arrested, he shall not be subjected to more restraint than is necessary to prevent his escape. For example, suppose a police is going to arrest a person and he wants to prevent his escape, he wants to escape. Then, while catching that particular person to be arrested, the police cannot go beyond, he cannot use more restraint which is necessary. For example, he cannot cause death of that person. This is one unnecessary restraint. The next section 57 provides that no police officer shall detain in custody a person arrested without warrant for a longer period than under all the circumstances of the case is reasonable, and such period shall not, in absence of a special order of a magistrate under section 167, exceed 24 hours exclusive of the time necessary for the journey from the place of arrest to the court of the magistrate. That means what? That a person cannot be detained more than 24 hours if a person has been arrested without a warrant. Next provision, section 57A provides that when a person arrested without warrant is produced before the magistrate, The magistrate shall, by inquiries to be made from the arrested person, satisfy himself that the provision of section 56 and 57 have been complied with, and shall also inquire and record the time and date of arrest. That means, as I have told you, the section 49 tells you, section 49 tells you that he shall not be that shall not be unnecessary restraint, and section 57 tells you that he shall not be detained beyond 24 hours. So 57A tells that when a person has been arrested, he has been produced before the magistrate, because after 24 hours he will have to be produced before the magistrate. After that time, the magistrate will have to satisfy himself that this particular provision has of section 56 and 57 have been complied with. The next provision in CRPC is section 163. It provides that no police officer or other person in authority shall offer or make or cause to be offered or make any such inducement, threat, or promise as is mentioned in section 24 of the Indian Evidence Act. That means the police officer or any other person in authority cannot make any such inducement, threat, or promise. But no police officer or person shall prevent by any caution or otherwise any person from making in the course of any investigation under this chapter any statement which he may be disposed to make his own free will. Section 164.4 provides that any such confessions shall be recorded in the manner provided in section 281 for recording the examining of an accused person, and shall be signed by the person making the confession. And the magistrate shall make a memorandum and the foot of such record to the following effect. That means what? If a person who is under arrest or detention, if he wants to or he's under the police custody or judicial custody and he wants to confess certain thing, there should be recording of the accused person of the confession, and that should be signed by the person making the confession. And that confession should be made in the presence of the magistrate. That is very important. So these are the provisions under the CRPC, that is section 49, 57, 57A, 163, 164. In short, I want to tell you that firstly, under the CRPC, section 49, which speaks of no unnecessary restraint should be used. Secondly, it tells that a person cannot be detained beyond 24 hours. Thirdly, if he is detained beyond 24 hours, he has to be produced before the nearest magistrate, and the magistrate will have to be satisfied himself that the provision of section, that means he has to satisfy himself that the provisions of section 56 and 57 have been complied with. Next is that the police officer or authority in charge, they cannot use any method of coercion, undue influence, or threat or promise to extract any confession or threat. Next, lastly, it tells